And the federal fraud statutes are so broad that it covers just about any type of deceptive conduct, as long as there is some misrepresentation, which is a fancy word for lie, to induce someone to part with money or property, which is always going to be the point of any fraud. In the federal code, they have very few specific fraud statutes. For example, they have healthcare fraud, they have bank fraud, they have securities fraud. But the prosecutor's darlings are really the mail and wire fraud statutes. And they cover any type of fraud imaginable. As a matter of fact, the statute is worded to say that any scheme to defraud, where misrepresentation is made to induce one to part with money or property, is a fraud. Almost every single commercial business dispute in which one side claims the other made a false representation could conceivably be a mail fraud or a wire fraud. But it's hard to conduct any transaction without either using the internets, the mails, or some type of commercial carrier, and it's hard to conceive of any kind of dispute in which an alleged false statement is made to gain property or money. So conceivably, almost everything falls under the federal fraud statutes. Now, in the state of Texas, there's also fraud statutes, but they're not near as broad. There are specific statutes for different types of fraud. For example, forgery, credit card fraud, use of identifying information, which is getting somebody's social security number, date of birth, or anything else that one can use to steal somebody's identity. But unlike the federal system, there is not simply a broad statute that makes all types of conduct in which misrepresentations are made fraudulent. In conclusion, in the federal system, almost everything can be a fraud. In the state of Texas system, it's limited to certain types of fraud.